Hi, welcome to Vermont Workers' Compensation Update. My name is Keith Kasper. I'm an attorney in Burlington, Vermont, doing workers' compensation defense work for the past 33 years. I've been doing this presentation for a number of years for the department. I'm going to apologize in advance for my Frankenstein scar and my black eye. This was not litigation by combat, which we used to do as attorneys back in the medieval times. Unfortunately, this is just some minor personal surgery. I'm fine, but it does give me a nice black eye. So this year I want to talk about everybody wants to talk about COVID. I'm going to start off with that as well as usual. Vermont did, as a state, did really well with COVID. We did have a number of unfortunate deaths and hospitalizations, and lots of people got it and got sick, but we were like #1 on the vaccination rate, and we had relatively few workers' comp COVID cases. They were certainly out there, and there were some people who really got sick, but as far as other states went, we really did not have the wave of COVID workers' comp cases that other states saw. Most of our workers' comp cases were exposures, staying home, be sick, and come back. The employer paid the 2 weeks that they're out. Medical bills were picked up. Relatively modest claims. Again, there were a few worse claims, but the vast majority of the claims were relatively modest. So Vermont really escaped what many other states faced with the workers' comp issues. We're not done with it, obviously, because we still have impairment issues to figure out, and long-term COVID issues may come back to haunt us in the future. But again, Vermont was very, very fortunate to avoid some of the problems that other states faced in this matter. So, COVID's not done by any stretch of the imagination, but we are much better than most other states. There are still the emergency rules. COVID emergency rules are going to stay in effect up until July 15th, which is just around the corner. Essentially not requiring job searches, can't get a Form 27 job searches, looking at extensions due to unable to get medical treatment, some other issues with the COVID emergency rules, but we found ways to address those, and I think everybody agrees that we did pretty well within the workers' comp litigation field as well with those emergency rules. It's not known at this point when we're going to get back to in-person workers' comp litigation. We've been doing things virtually for the past year and a half now. That's going to continue for a little longer. The Vermont Superior Trial Courts are slowly starting to open up, but they've got a lot of restrictions. And I don't know what the plan is to get back into in-person litigation. It will come at some point. Probably not this week or this month, but at some point in the near future. Some other background things. Beginning of this year, the department adopted a rule. There was a statute that was adopted that requires the carrier to pay weekly indemnity benefits via direct deposit if the claimant asks for it. So before, it was at the discretion of the carrier and the claimant that if they wanted to have direct deposit, the carrier was willing to do that, they could arrange direct deposit. There was some costs involved in that for the carrier's perspective, so lots of them didn't do it for a variety of reasons. Now, if the claimant asks for it, they're required to do it. Obviously, avoids lots of the missing check issues, so the payments are more regular, more timely. It's still not a perfect system about when the money is issued from the carrier and deposited into the claimant's accounts, but it greatly eliminates most of the delay issues there. They still exist, but it's been a whole lot better. Certainly not everybody is going to have direct deposit. There are some claimants who don't have checking accounts, but I think most claimants who are aware of this rule and are out for an extended period of time, direct deposit, just like you and my paycheck gets direct deposited, weekly indemnity benefits getting direct deposited seems to make a lot of sense, and is going forward with not a whole lot of issues as far as I'm aware of. The other thing that came about this year, Department of Labor came up with some new regulations as to privacy concerns And so they've encrypted emails for anything containing medical records. So if you're going to file a Form 27 via email with all your medical records attached, that's going to have to be encrypted, or it's going to get bounced back by the department. Again, all you got to do is contact the department, say, hey, I want to send you this these medical records. They send you the link for their encryption service, and then you just file it through that. So it's not overwhelmingly difficult. It just is, one more thing to pay attention to when you're sending the department any information, that if it's anything to do with medical records, it's got to be encrypted or they're going to bounce it back at you. And then finally, most surprisingly to me anyway, was the annual cost of living adjustment increase taking effect on July 1st of 9.8%. This is by far and away the highest COLA increase that we've ever seen since COLAs came into effect back in 1975. So back in 1975, the legislature created the cost of living adjustment, which again is the idea of we're going to increase the maximum minimums and your annual indemnity rate based upon a cost of living adjustment. Interestingly, though, it's not directly related to the CPI, because the CPI only went up about 4%. So if you look at the attorney's fees and VR attorney's fees issues, they only went up by 4%, which I'm sure no one's going to be crying about the attorneys making less money, except for the attorneys, obviously. But that went up fairly modestly, and the overall inflation rate has been up more than it's been in a while, but not up nearly dramatically as 9.8%. The cost of living adjustment is based upon wages and not inflation necessarily. There was a similar rise in unemployment benefits, which are also adjusted to wages. So good news for Vermont employees is, they're making a lot more money than they made last year. Good news for the claimants, that they're going to be making more money than they did last year. It is going to be an increase for the carriers paying out. It affected my settlement analysis letters, because I presumed we were going to have something on the neighborhood of the normal 2, 3, 4% range. And settlement letters I issued, back analysis letters that I issued back in the beginning of June, talking about what the potential exposure is going to be, had to be rewritten because it went up way further than I had anticipated. Again, it's not going to have a huge impact on the claims, but it is going to, if you got a 20% impairment to the spine, it's going to add $5 grand, 10 grand, depending on what the numbers you're talking about, to the settlement. It's it is a significant increase, far more significant than anything that's ever happened before. The second highest one was back in 1980 when it was 8.3%. Just because I know you're all interested and I'm interested, the lowest COLA increase was in 1994, when it was less than half, was half a percent, 0.6%, not 6%, 0.6% increase. So you can see the range there, 0.6% on the low end back in 1994, 9.8% today, which is the highest. Again, historically, it's been 2, 3, 4% in that range for the majority of years since 1975 when it came into effect. That, given its big increase this year, I suspect next year won't be anything near this. That 0.6% increase back in 1994 followed a relatively high 5% increase back in 1993, or something thereabouts back in 1993 before. So again, when you have a big one, sometimes you get a smaller one afterwards. Again, averaging out in the 2, 3, 4% range. Whether it goes up, I doubt we're going to see 9.8% next year, but it was surprising. The other thing that was surprising is we had 3 Vermont Supreme Court decisions in workers' comp just since May, which is pretty highly unusual. I think probably the most important one for practitioners in the long term, especially attorneys practitioners in the long term, is the Zebak versus Rhino Foods one. 2021 Vermont 35 came out in May 21st of 2021. This is a split decision between the court and Justice Robinson in dissent. Justice Robinson agreed with the result, I guess not really dissent, but concurrence. Justice Robinson agreed with the result of denying the appeal, but suggested that instead of you're out, you're done, with this claim. Her recommendation was to allow for the rejected certified question to go to the Superior Court. So what happens in this case is in 2017, the claimant has a subarachnoid hemorrhage, result from a ruptured aneurysm in her left medial cerebral artery, which was, obviously a very significant injury. She goes to the hospital, has some significant surgery, is out for a extended period of time, lots of resulting problems from that. The issue was whether that hemorrhage was due to a 2015 work-related knee and back claims. The allegation was that the increased pain, the treatment she was getting, was led to increase in blood pressure that resulted in the hemorrhage, an aneurysm. She got the claim. The treating physician said they couldn't tell. It couldn't say within a reasonable degree of medical certainty that it was caused. It was plausible, but they couldn't meet that standard. Claimant got an IME doctor from Dr. Zwibar, who used to be practicing in this area, now is practicing in California, I believe, to say that it was related, and rejected some of the blood pressure readings that had been found at previous office visits prior to the hemorrhage, saying that they weren't accurate. The defendant, this was done by one of my partners, Dave Berman, got an IME doctor. He said, this is not related, and looked at the prior blood pressure records and said, not work related. So at the department level, they found the claim wasn't work related, and the claimant appealed to the Superior Court on the issue of, is this a work related injury, but added a certified question that whether or not the standard should be not within a reasonable degree of medical certainty, but rather changing the standard to plausible. Is it plausible that this injury happened, rose out in the course of employment, or plausibly related to this work injury, as opposed to within a reasonable degree of medical certainty for expert opinion? So the idea was, we're going to have this claim litigated on the facts, and we're going to have a claim as to what's the appropriate standard. So the appropriate standard obviously is a legal issue. The facts are a factual issue. Claims counsel appeals that to the Superior Court and says, this is what I want to try. The commissioner refused to certify the plausibility standard, saying that's a legal issue. You can't appeal that to the Superior Court. That's got to go up to the Supreme Court. And based upon some previous decisions from the Supreme Court in Letourneau and Rothke and a couple of other cases, says, look at, legal questions have to go to the Supreme Court, factual questions have to go to the Superior Court, and nary the twain shall mix. And so the problem has arisen and has been noted by the court and practitioners for a period of time, is that if you have a case at the department that you want to appeal, you have this choice. You can appeal to the Superior Court only on the issue of facts, or you can appeal to the Supreme Court only on the issue of law. Or if you appeal to the Superior Court, you're giving up your claims for legal issues, whereas if you appeal to the Supreme Court, you're giving up your factual arguments. So you have to choose which way you want to go, and you're giving up one or the other. And so the argument has been, well, if you want to mix them, because the appeal statute says mixed questions of law and fact go to the Superior Court, can't you certify legal issues there because you have some factual issues as well? Again, the commissioner refused to do that. The Supreme Court agreed, saying that they lacked jurisdiction and was precluded from addressing it by the concurrent appeal to the Superior Court. They left open the question of whether the Superior Court can address the plausibility standard, but they weren't going to allow it to continue. Justice Robinson, in her, agreed again that the Superior Court has jurisdiction over the claim and not the Supreme Court, but wrote a dissent asking for clarity as to, quote, confusion or surrounding appeals from the Commissioner's workers' compensation decisions, and specifically allow for the Superior Court to address the legal issue as to the appropriateness of the plausibility standard. Her great line in that dissent is, the remedial workers' compensation statute is not a game of gotcha, and given claimant's timely filing of her notice of appeal raising the legal questions she seeks to address and appeal, we should transfer the remaining certified questions to the Superior Court. So the issue is, when this case, gets to the Superior Court, they get to the jury, trial, the judge is going to have to, let the jurors know what's the standard for expert opinion, and is it within a reasonable degree of medical certainty, or is it mere plausibility? This would be a major change, by the way, in the way we address these expert opinions. So I'm not real optimistic that the Superior Court would say, oh yeah, we're going to change the standard to plausibility from within a reasonable degree of medical certainty, despite the remedial nature of the Workers' Comp Act. I don't think that's going to change, but the underlying issue really is, what do you do in these circumstances? Are you foreclosed from bringing these types of legal issues to the attention of the Superior Court? How is the Superior Court going to instruct the jury? Are they going to be bound by the Commissioner's determination of the law and the Supreme Court's determination? Obviously, they're going to be bound by the Supreme Court's determination of the law, but are they going to be bound by the Department of Labor's determination of the law? Can they not say, we don't agree with that, and instruct the jury in some other manner other than in this case, I don't think they would anyway, but do they have an opportunity to look at the legal issues there, or is that taken away from them entirely? So Justice Robinson's solution to that was either tell the legislature, again, they've said this several times and the legislature hasn't done anything about it, to change the statute to get rid of that confusion, or to allow the Superior Court to address these, transfer that question to the Superior Court. Now that the Supreme Court has refused to do that, I'm sure defense counsel at the department level is going to say, this is collateral estoppel. You cannot make that argument. This is the Supreme Court has said you can't make the argument for plausibility. So it's an open issue that needs some resolution. There's been some confusion over this for the last decade at least as to how to deal with these types of situations. And so, hopefully the Supreme Court or the legislature will, do something about it. Or if not, then the ZVEC question remains that you can't do this. Although, again, the Supreme Court left it open as to whether the Superior Court could do it or not. I'm sure once we get done with that, there'll be an appeal to the Supreme Court on that issue. So stay tuned in a year or two, probably two, as things have backed up with COVID as a jury trial. Civil jury trials aren't going anywhere at the moment. It's going to be probably a couple of years before we get a decision back to the Supreme Court, if the Superior Court takes that, and if the parties don't resolve the claim in the next couple of years anyway. But again, an ongoing issue as to how you appeal from the department on legal issues, in fact, mixed questions of law and fact. The other case that came down that was not a big deal, came down on June 11th, is Reese versus Wyndham Supervisory Union, 2021 Vermont 48. This was another one of my partners, Jason Pereira. This was not a big surprise here. This was a pro se defendant who had raised the issue at the Department of Labor, and the department had rejected their claim on a compensability issue. It was a PTSD claim, and the only support the claimant put forward at the department level was a nurse practitioner letter that, quote, offered only conclusory statement that claimant's self-reported incidents qualified as harassment, exacerbated his anxiety, or triggered his PTSD. The nurse practitioner's letter did not specify what incidences allegedly occurred, did not provide any detail regarding claimant's symptoms or increased anxiety or stress, did not include any causal analysis that rejected other possible causes for his reported increased anxiety and stress. So both the department and the Supreme Court says, if you're going to go forward, and I think this not only on PTSD cases, but essentially any type of medical expert opinion you're looking at, it behooves you not to get just the conclusory report and said, yes, we believe this injury is related to his work. You need more than that. You're going to need some analysis as to what happened at work. And we'll see later on in this materials that make sure you're right about what happened at work, because if the claimant's not credible on that, that's another way to lose their case. But A, what happened at work, and B, from a medical, usually physiological perspective, how did what happened at work result in the injury? And again, absent the plausibility standard, within a reasonable degree of medical certainty. So again, it's helpful for the doctors to get these conclusory statements that saying, yes, I believe it's related to work. That'll get people's attention and get you in the door, but that's going to be subject to a motion for summary judgment if you don't have anything more than that. So again, you need some correlation as to exactly what the diagnosis is. Usually we talk about the symptoms, and most importantly, causally relating that diagnosis to what actually happened at work on a somewhat more detailed basis. Again, the mere conclusory statement to that effect is not going to be sufficient to meet the compensability standard. And then finally, we also had a really interesting case from the Department of Labor on more procedural grounds than substantive grounds. But this deals West versus North Branch District number 1, 2021, Vermont 44, came down on June 18th. This is a really interesting history that the court did a deep dive analysis on this. So essentially what happens here is that the claimant has pre-existing injuries, has another work-related injury, and has a traumatic brain injury type situation that results in both physical and mental problems. And the issue is whether he meets 644A subset 6 definition, which gives you the per se total disability. If you lose both your legs, an arm and a leg, both your eyes, you're automatically qualified for PTA, for a permanent total disability. You don't have to show anything other than the loss of those body parts. So as a lawyer, I like my legs, and they're useful, but I could lose both my legs and continue working, but I could still be qualified as permanent total disability. So it's a very important way. Most cases don't meet those criteria because most of our accidents aren't that severe that they end up there. So most permanent total disability claims fall under B, the kind of the odd lot doctrine type cases that look at education, BR, more kind of holistic approach to whether someone's permanently totally disabled. 644A just looks at a mere body loss function. And again, look back to how the workers' comp system came about. It's the balancing between the rights of the grand, as Glenn Morgan says, the grand bargain between the employers and employees, balancing the quick remedies available to the quick no-fault remedies available to the injured employees and the limited liability allowed to the employers. So 644A kind of addresses that says, with permanent impairment as well, we're going to give 20% for an impairment rating for fusion on the neck, even if you got a great outcome. You have no more pain, you're fully functioning, you just have this fused disc, you're going to get at least 20% minimum under the DREs, as opposed to a more holistic approach of saying, I may have only a 5% low back impairment, but I'm totally disabled due to pain and my lack of education and job skills, et cetera, et cetera. In this case, it's 644A6, which used the politically incorrect term back from the 1940s, I think it was, when the statute was written, that's used the word imbecility. So if you had an injury to the head that resulted in imbecility, that gave you a permanent total disability claim. That's not a very, retarded imbecile. Those are really the politically incorrect and not the, the proper terminology that we're used to today. So in 2014, the legislature amended the statute to get rid of the word imbecility and looks more at, traumatic brain injuries causing inability to work. So it makes it, brings it up to date, more consistent with the modern articulation of, insanity standard. You're incapable of being employed because you're insane. You don't have to be criminally insane, but you're just not going to be able to meet the standards for sanity. So the argument so what happens is the claimant and defendant's counsel have a deposition of defendant's expert who uses the word imbecility, and the claimants make a motion for summary judgment that is denied by the Department of Labor, saying, we don't utilize those terminology. The department made a change that to the statute back in 2014, which resulted in a substantive change to the doctrine, the statute, even though the legislature, when they enacted that legislation, said explicitly that they did not want to make any substantive change. This was merely a procedural change. So the differential is, if it's substantive, it applies retroactively. If it's procedural, it does not. So they applied it retroactively and said, you know, we're going to utilize this terminology. Excuse me. The claimant tries to make an interlocutory appeal to the Supreme Court to say, hey, this is just a, you know, we have to know what terminology we're going to be utilizing when we go to formal hearing in this case. And the Supreme Court, the department, you know, certifies the interlocutory appeal, which are not typical, but is allowed for legal issues only. Supreme Court says, we're not going to take it. You know, they reject the interlocutory appeal. So it goes back down to the department. At the department level, interestingly enough, the defendant then again moves for summary judgment in favor of the claimant, saying, you know, they're not going to be able to meet that standard because they're not using the words properly. They, you know, reserve their rights to say, look, we're still arguing about which terminology we should be using, but if we're using this, we can't meet it. Department grants that summary judgment motion in favor of defendant, even though it was brought by the claimant, which is again highly unusual. But that allows for a final judgment, which allows for an appeal to the Supreme Court. At the Supreme Court level, the Department of Labor takes a very lengthy history of the use of the term imbecility in the workers' comp context and concludes ultimately that, well, our ultimate conclusion on the retroactive effect of the 2014 amendment, excuse me, to 644A6 must be based upon the substantive analysis of the statutory amendment. Excuse me. Our analysis is informed by the legislature's express statement that intended the 2014 amendment to rephrase existing law in more respectful terms. Consistent with the providing a modern articulation of the incurable imbecility and insanity standard, the 2014 amendment makes explicit that severe brain injuries may result in physical disabilities. So essentially what they're saying here is we're going to take the legislature at their word. They reverse the department's decision and say, look, you got to go back and try this case using the 644 amendments. We're not going to apply them retroactively. They're not substantive. They're procedural, and therefore, you got to utilize the terminology properly. Also of note is that the defense had argued that the claimant can't be permanently totally disabled because they're still working. And again, the Supreme Court says that under 644A, unlike 644B, claimant's actual employment is irrelevant to the determination of PTD. So again, really interesting case, really great summary analysis of the history of workers' comp and brain injuries and imbecility and insanity. Lengthy decision. If you like the history of how things have gone on, it's a great read. Procedurally, it really goes back to what the legislature intended. And again, the legislature clearly intended that. The department had said, words have meanings, even though the legislature may not have intended that. They did make a change, and therefore, they decided that it was a substantive change, not a procedural change. So again, an interesting read if you're into that kind of thing. All right, then we move on to the Department of Labor decisions. So we had 12 decisions to date for 2021. We just had a 13th that just came out on the 1st that I haven't had a chance to incorporate into these materials yet. So I apologize for that. It was just too soon for me. I didn't find out about it until this morning. My partner Jason was also involved in that, but again, I haven't added that to it. So there's 13 decisions to date. Last year in 2020, there were 21 decisions. So, halfway through the year, 13 versus 21, we're pretty much there. Again, 2020, we were in the midst of COVID lockdown, so things were moving a little slower. So the department's probably going to get something in the 20-25 range for decisions. So, but looking back at the past year from July 2020 to today, There are a bunch of decisions that I'm going to quantify as being trial procedural issues as opposed to substantive issues of PTD or somewhat along those lines, but really just how you formulate and present a case. So I think the most important one is this Holbrook versus Ken Metal 2 case. This has been up and down in the department a couple of times. So this deals with settlements. And so what happened in this case, the parties go to mediation, they finally reach a settlement. It's including an MSA to be submitted to CMS. Claimant objects to that MSA that is submitted to CMS and approved by CMS, alleging that it's underfunded in the amount of $4,700 over his lifetime for certain medications. Because the MSA is underfunded and approved, claimant refuses to sign the Form 16 and settlement addendum unless the defendant's going to pay them that other $4,700 outside of the MSA. Defendant refuses to do that, files a motion to enforce the settlement. The department denies it, saying, look, there's no Form 16 approved. We can't approve a settlement, even though they came to an agreement at mediation. The department has a rule that no settlement is approved until executed by the parties and approved by the commissioner. So because it hasn't been submitted to the commissioner, claimant withdraws their consent to it. The department's not going to approve it if the claimant agrees to it. So again, the issue here is it's not, settlement doesn't happen until the commissioner signs off on it. What's the old saying of it's not open until they sing. Here, no settlement is effective until the department signs off on it. Interestingly, once the department signs off on it, the department has historically been pretty strenuous about what happens thereafter and says, look if you signed off on it, you got the money, unless you're going to show fraud or something really extraordinary, we're not going to let you out of the settlement. You came to a settlement, once you come to a settlement, the department approves it, they're going to enforce it and not let the claimant out of it or either side out of it once it's been approved. You got to pay up according to what happens. We do allow for amendments, especially with annuities. If there's some problems with that, they can kind of rework those things because otherwise the annuity company is not going to pay. It's going to be a big mess. And both parties agree to it. The department will agree to an amendment if both parties agree to it. We've had amendments for, doing the integration with SSDI. But again, unless both parties agree to an amendment, then once the Form 16 happens, it's done. Before the Form 16 happens, it is not done. So compare that to the other decision, Omerick versus UVM Medical Center, which is 1320, which came out slightly before that decision. This is the third iteration of the claim. Omerick 3. The prior cases found certain facts in favor of claimant and certain facts in favor of defendant. The claimant, brought forth another claim, essentially arguing that there was excuse me, an aggravation, and mostly, what the proposed treatment is going to be for, whether that's going to be for the, work-related injury. So this is a 2015 work-related injury, and symptoms occurred on July 8th of 2019. They wanted to put in facts as to when those symptoms arose. The department says, you're going to be collaterally stopped from arguing that those facts, but you're not going to be precluded from making an argument of flare-up recurrence. So again, the facts are going to be set under collateral estoppel. Collateral estoppel is a legal term that essentially says you can't re-argue certain issues. Res judicata is where the whole case has been resolved and you can't relitigate the case. Collateral estoppel does allow you to relitigate the case, but it's going to limit your presentation certain issues or certain facts that have been definitively, resolved in prior claims. So here, this third time up, a lot of stuff has already been definitively determined in the previous two. Those factual issues have been resolved, and claimant was not going to be allowed to re-argue those. But the issue of a flare-up or recurrence for 2019 treatment had not been resolved because this is a 2020 claim, relatively recent. As these things go, the theory was not precluded, even though the facts, certain facts have been precluded. So again, the claimant's going to be able to argue flare-up or recurrence but it's going to be limited to what facts it can argue, it can bring forth in support of that new theory. So here, again, with the Holbrook case, we're saying once the settlement, settlement doesn't happen until we sign off on it, but once it happens, we're done. Here under Maravik, we're saying, once we have a decision on those facts, you can't retry those facts. But if this theory of liability hasn't been tried before, we're going to allow you to do that. So, again, there's some work on the departments have to allow for a full argument of all things possible for the claimant. Again, the department, the carriers would have the same power in these two cases. It was the claimant making these moves to try and get out of the mediation agreement or get out of the factual issues that have been resolved in some of the previous litigation. Some other things that came forth at the department level of, whether you, come forward with a live witness or not. So surprisingly, Schwartz versus Avatron, opinion 8-21 came back in April of this year. This is a permanent total disability claim. And, there's a lot of stuff going on here. Claimants Counsel decided that the case was so strong, they didn't need live testimony from the expert. They just relied upon a deposition. And they still won. They won on an odd lot doctrine based upon a 2013 work injury predating the 2015 rule changes that explicitly allowed for the odd lot. We've argued in the past whether odd lot applied prior to 2015 rule change. The department seems to accept the fact that odd lot was already adopted pre-existing the 2015 rule change, and that a Supreme Court has, sort of in backhanded fashion under the West versus North Branch case, by referencing the Fleury versus Kessel-Duff argument, also seems to suggest in some manner that odd lot may have been in existence before. We haven't had a case at the Supreme Court that directly addressed that issue, to my knowledge, but it's been whittled away at in the department level, and sort of has an offhand blessing in the Supreme Court West, but it may be for another argument for another day as to whether odd lot, arises pre-existing the 2015 rule change. It's important to the extent that, we under Montgomery versus Brivner, the substantive law at the time of the injury is what governs. If it's, again, procedural changes that happen after that, the new procedures will take effect. But if it's substantive, we're stuck in time back, in this case, back to 2013. But again, the department says we already had odd lot prior to 2015, so we're going to allow it here. Again, Claimants Counsel didn't put on live testimony from the expert witness, but he did. Claimants Counsel did have an FCE that said no work capacity. BR had written that there's claimants going to be unable to to return to regular gainful employment. There was some dispute as to causation from defendant's IME, but the department ruled in favor of the claimant and found that they were permanently totally disabled. So compare that to the Reese case with summary finding says that wasn't sufficient, and also compare that to the Fitzgerald versus A.M. McKenzie case of 1720, October 20th. Here, the pro se claimant fails to have the treating doctor testify at the formal hearing. The department in that case found that, quote, without the benefit of treating physician's sworn testimony and with no opportunity to allow her to explain how a corrected factual account of claimant's injury history might affect her analysis, I cannot attach any weight to Dr. Henley's causation's opinions. So here, the claimant, probably because they couldn't afford to have the doctor testify at the formal hearing, just relied upon the treatment notes. But it appears that at the hearing, or maybe prior to that, there was some dispute as to how the injury arose, and so the injury history changes. Does the causation opinion remain inviolable? And here, clearly not. So if you have some different disagreement as to what happened, it behooves you to have the treating physician available. Now, there's going to be some problems about disclosure, but if that if the issue doesn't come up until the hearing, you're probably going to be allowed to get expert opinion in as to hypotheticals as to hypothetically, doctor, if X, Y, and Z happened as opposed to A, B, and C, which you based your opinions on, would that still be compensable? That's up for the administrative law judge to decide. I'm presuming that if the issue didn't arise until the morning of trial testimony with the claimant, they would allow it to a certain extent. If it came up, 6 months ago, and you didn't get that to the expert opinion, prior to that, then you might have more of a problem. Usually more on the defense side, we get our IME, X, Y, if they believe the facts are A, B, and C. If the facts are actually X, Y, and Z, you better get those facts to that IME doctor and say, if, instead of A, B, and C, if X, Y, Z actually happened, how, if at all, does that affect your opinion? You can disclose that. Again, we generally have a 30-day disclosure window prior to formal hearing. If it comes up late, the department's been relatively liberal about allowing for late opinions. Not always, depending on the circumstances, but as a general rule, they've allowed those types of things to come in as necessary. Similar to that, along a similar vein, is the Brochu versus Peck Electric decision from opinion number 1820, came out in November of last year. Here, the claimant's testimony was found not so credible as to how the injury claimed. Again, the claimant's IME doctor's opinions as to how he suffered the injury were based upon a factual misunderstanding, and therefore, if his opinions are based upon the wrong facts, his opinions are not going to be as persuasive if they were based upon the correct facts. So if you've got a claimant whose testimony is unreliable, you got lots of problems. Only one of which is, if the treating experts' opinions of causation are all based upon this unreliable testimony, as opposed to some other more reliable testimony, then how are you going to support the reasonable degree of medical certainty? Again, if you go to the plausibility standard, maybe anything can come in, but I don't think that's going to happen anytime in the near future. So, moral of the story here is, you can get away without having live testimony from your treating expert opinion, but it's going to be, usually the safe bet to have them testify. And again, workers' comp, we've historically not had doctors show up physically to testify at trial. The vast majority of doctors testify telephonically, or now we've got, Zoom or Microsoft Teams. They've been testifying, virtually, like all the rest of us, doing everything virtually, and that has worked really well. So I don't really think we're going to see, that change in the near future. But the idea of not calling a witness at all is dangerous for your claim, either side, claimant or defense. It can certainly, as the Schwartz case shows, you can certainly get away with it and win the case without it. But as the Brochu and Fitzgerald and Reese cases show, not having them to have the ability to explain how the expert's opinions came about, or if there's any change in the understanding of the facts of the case, it becomes more problematic not having them available to testify. And finally, under the procedural issues I'm going to qualify is the Stearns versus McCain case. 1121 came out in June of this year, June 14th recently, just the dangers of ignoring the department. So here, there's an employee working for an uninsured employer since 2006. Excuse me, goes out of work in 2015, doesn't come back to work until 2020. No Form 27s filed in this whole time. Employers, to a large extent, just blowing off, appears to be just blowing off the department for pretrial conferences, status conferences, et cetera, et cetera. Department has a hearing and awards $240,000 of TTD from 2015 to 2020. I'm presuming that if this was an insured carrier and the carrier was involved, they would have stopped TTD benefits sometime before the $240,000. But maybe not. But the $240,000 award, I'm not really optimistic that the personal defendant, since they're uninsured, again, remember, it's not just the business corporation's assets that are at risk, but the personal assets of the officers and directors of the corporation. In this case, they all seem to be the same person. But I don't know about you, but writing a $240,000 check would be really difficult. Fortunately, I could probably do it. I'm not sure Mr. Crossman in this case would have the financial means to do that, and he clearly doesn't have the interest in doing that given his history here. So they awarded $240,000 for TTD benefits, $15,000 for medical benefits, plus attorney's fees and costs, which I'm sure are not going to be cheap since it's been going on for so long. So it's going to be that's a big hit if they win the lottery. There's going to be a lot of money being shifted over there. They also, for reasons I'm not quite clear, referred to the defendant for prosecution for failure to comply with an inner order and failure to maintain workers' comp insurance. So usually when you get an employer who doesn't have workers' comp insurance, it goes to another part of the department that have a fine primarily based upon how much money that the employer saved by not having insurance. I've currently got a case where they only, between the time of the acts, they had no employees, they hired an employee, 6 days later, the guy gets into a motor vehicle accident, not his fault. Somebody else hits him, but, is out of work for over a year now. There they only had, 6 days, the employer trying to go get insurance, but, it's the end of COVID, loosening up of COVID, and decided to get a haircut instead, a very expensive haircut for her and her business. So in that case, there was a very short period of time between the time that they, had the employee and the time they got workers' comp, less than a week. They were making efforts to get the insurance at the time of the accident. They had no history of having this problem in the past, so that was a pretty minor fine of a few $100. Usually, again, there's going to be something for this length of time. I'm presuming that would be much larger fine for them to have workers' comp insurance. You can also get prosecuted, either individually or as an insurance carrier or attorney or whatnot, for failing to comply with an interim order. We always say that there's this out there. It occasionally comes up of, do I really have to follow this order? I think it's so unfair. The answer is yes. You do have to follow the interim order or face these prosecutions. And they're really not, the fact that you think you might win, the stay provision, is pretty much irrelevant. You have to show that you're going to win and you already lost. You have to show that there's not going to be any prejudice. There's going to be some prejudice to you for if you don't get a stay. And the department has long held that prejudice does not include paying money that you're not going to be able to get back. So given those scenarios, it's pretty unlikely that any stay is going to work, and there's really, no legitimate defense that I'm aware of, that I've seen anyway. I guess there are legitimate defenses to avoid an interim order, and it has come up one occasion in the past where they appealed it. They were appealed it, and the Superior Supreme Court, I can't remember which, but one or the other of them reversed them, and that was a good reason to ignore the interim order. But generally speaking, you do have to comply with the interim order, or you're going to get additional fines on a daily basis. And paying indemnity benefits is one thing. Paying a fine is much different. Penalties and fines get accounted for differently than benefits out there. So it's not something that I can recommend to anybody for any. I guess there could theoretically be a reason for not to comply, but I've never personally done it in 33 years, so I doubt that's going to happen. Okay, so moving on to compensability issues, probably the most interesting case that the department came down with this year in 2021 is the Rainville versus Boxer, Blake and Moore case from January 2021. It's opinion number 2-21. So this is a situation where there's a lawyer working for a workers' comp defense firm. She is gluten-free. She's traveling from her normal office to another office that the firm has in Burlington, and says, "Hey, getting there to prep the client for a mediation. Client's already there, doesn't have time to get lunch, so she talks to the secretary who's working at that remote office and who's also has gluten issues. Says, hey, let's get a pizza together from a local pizzeria that they know has gluten-free pizza, and the secretary goes and orders that pizza. Turns out it's not gluten-free, and she has an allergic reaction that has a cascade of health effects thereafter. Essentially, significant problems alleged thereafter as a result of eating that gluten. So the issue was whether or not having that pizza that rose out of in the course of her employment. So again, remember, Vermont has the very broad-based compensability determination that says, but for the work, you wouldn't have been in this situation. Excuse me. We don't have the proximate cause, more traditional liability proximate cause relationship that requires a much more focused relationship between work and injury. We have the positional risk doctrine. So, but for work, you wouldn't have been in there, you're going to get compensability. So the argument here was, but for work, I wouldn't have shown up at this location, and but for the person being there early, I would have gotten lunch on my own, as opposed to getting somebody else to get lunch for me and relying upon them and not doing that correctly, allegedly, and having these reactions. So there is an older case dealing with the town of Milton that the patrolman buys a burger and is eating it at his desk while he's working and bites into something in the burger and breaks a tooth. That was one of the cases that said, this is not compensable because, the employer has no control over what you decide to get for lunch. So, if I get, lunch and I get food poisoning from bringing lunch from home, that's not my employer's fault. There are cases out there that says, there's a famous case where there's a food truck that came to the food site that was somewhat remote work site, so it saved time for people leaving from work. The food came to them. Guy orders a chicken sandwich, gets salmonella poisoning. That was found to be compensable because there was a benefit to the employer. In the town of Milton case, police officer case, there was found to be no benefit to the employer because even though he's eating and working at the same time, there was no responsibility from the employer's perspective as to how to control that. There's a classic line in that case about, neither the employer or employee could stomach having the rule that the employer is going to be responsible for what you bring to lunch. So relying in part upon that, in the Rainville case, the department finds that, quote, while the time pressures of her workday certainly influenced claimant's choice about how to obtain her lunch, it was still her decision to choose pizza and to form an agreement with her coworker to place the order. Under these circumstances, the risk of gluten consumption was not incidental to the conditions and obligations of her employment. As a matter of law, her wheat pizza consumption therefore did not arise out of her employment. Clearly happened in the course of her employment because she was at work. And in most compensability cases, it arose in the course of employment, it arose out of the employment. So this is, not unique, but unusual to the extent that it occurred in the course of employment, but did not arise out of. So here, there's a line being drawn under whether or not you're going to, if you get to eat something at work and you eat it at work, does that make it compensable? The department made a distinction saying if this was a pizza party where we're going to have, celebrate somebody's birthday and we're going to bring pizza in to celebrate somebody's birthday or something else, that would be a much closer context because we're doing it due to work-related. The employer's taking control over this. Here, the individual took control over to choose pizza for lunch and to get the coworker to place the order. So again, there's a line being drawn that positional risk doctrine is not all encompassing. There are situations where they may arise in the course of it, but do not arise out of the employment. Other compensability cases. So again, that's, I think, the most important compensability case that I think is the most important case that the department has issued this year, but the year's not over yet, as they say. Other compensability cases that's of interest is the Whitney versus Porter Medical Center case. It's opinion number 10-21 from May of this year. Here, the claimant's low back injury claim was denied. Claimant had a long history of pre-existing back complaints. And importantly, there were no complaints of back pain to medical providers for more than a year post-accident. So the claimant's IME doctor couldn't make a sufficient medical basis for forming opinions of aggravation due to the work injury, the compensable work injury. But the back injury, was found to be a flare-up of a prior back injury. So they didn't find it was an aggravation, but they found it was a flare-up. So it allowed for some period of TTD benefits, but no permanency. So again, going back to the aggravation versus recurrence versus flare-up analysis, aggravation is, the condition is made worse. The new employer, new insurance carrier is on the hook for all medical treatment. The only apportionment we allow in Vermont is for apportioning permanency that's been previously awarded or previously determinable, which, again, if you're not in a workers' comp, why would you get an AMA guide rating? So it's, it happens, but it's not all that frequent. The recurrence is it all goes back to, you may have symptoms now that you didn't have before, but it's all relating back to that original injury, and it's the original carrier's responsibility. The flare-up is a little bit in between. It's saying, yes, your symptomatology is worse than it was, but once you get back to that same baseline of pain criteria, now you're going to go back to the original carrier. I had a case like this many, many years ago. Fortunately, there was a person was getting ongoing chiropractic treatment, and right immediately before the incident and immediately after the incident, we were able to chart and say, look, this is what they were like, the week or 2 weeks before the incident. Now they're back to that same level, 4 or 6 months later. Now they're back to baseline. There was some good evidence on both sides. With flare-up, generally it's a little more problematic as to how to define what the baseline is. Unless you've got ongoing treatment for it. If you've got gaps in treatment, that's not going to be, it's going to be more difficult. Here, there was an ongoing, treatment, but there was no complaints of back pain for more than a year. They said this is not an aggravation. Other compensability cases, the Gallo versus Costco case is pretty interesting. Here, an employee for Costco says, I'm going to resign, has a work-related injury, keeps working, but says, look at, I'm going to leave and go to Chicago. My daughter's going to have a baby out there. She's going to have problems. I'm going to quit my job and go out there and take care of her. That she has an exit interview where she doesn't mention that her work injury is contributing to her departure, but importantly, they also have a backup exit questionnaire that does relate the departure to injury. Here, she doesn't attempt to go back to work for an extended period of time after she goes out to Chicago. Daughter has a baby, no significant problems out there. COVID hits, there's all sorts of problems getting into surgery. Finally has the surgery, but she hasn't worked for 26 weeks prior to the surgery. Therefore, she has no wage loss. So this is really, interesting in that, there's delay in the treatment, not entirely due to the claimant's fault. And during that time frame, she doesn't have any earnings, so there's no TTD benefits because there's no wages to replace. Also, this is an interesting thing, because we usually rely upon documentation as opposed to oral statements. Here, there's documentation that says her departure is due to the work injury, but her exit interview was not related to it. So the department found that the oral statements were more important in this case. It was important in that if she had left work, she would be in a better position to argue that the disability after the surgery should be based upon her pre-injury average weekly wage, as opposed to the 26 weeks prior to surgery. She would have been entitled to temporary partial disability benefits and other types of things if she left work in part to her work injury. Here, given the totality of the circumstances, the department determined that she left work for reasons unrelated to the injury. She had been working right up to the time she quit. She didn't try and go back to work anywhere else after that. So, again, it's not every time that the evidence is going to support that type of situation. Similarly, Ali versus the University of Vermont, 2020 came out in December of last year. There was an unwitnessed late reported injury. The departments found the claimant very credible on substantially all material and contested factual issues. The claimant was not, consistent on everything, but he was consistent on the most important things. Here was also interesting in that the claimant's IME as to causation was found to be supported, but the defendant's IME as to medical end result and impairment rating were accepted because both doctors agreed that the claimant was at medical end result, but claimant didn't have an impairment rating for reasons unclear. So if the only evidence out there was everybody agrees they're at medical end result, but we don't, but there's only one impairment rating out there, the department's going to have to take that one impairment rating, absent again fraud or something horrendous, because that's all that's out there. The other interesting case came down is Martin versus Carroll's LLC 2120, also came out in December. Here, the defendant's IME doctor related the claimant's problems as to somatoform disorder, and also had alleged that there was some childhood abuse and self-destructive behavior that the claimant denied. There was no no documentation to support the childhood abuse or self-destructive behavior in the records. And so therefore, the department found that, quote, although defendant's IME credibly testified about some non-organic findings, those findings do not necessarily rule out a physical injury. Further, there is no credible factual basis for his testimony that claimant suffered childhood abuse or that she engages in self-destructive behavior. Therefore, the claimant's IME doctors found to be more credible as to causation and the 15% spine impairment. So again, some doctors, you got to watch out for them, trying to overreach, I think, is the issue as to, especially with somatoform disorders, what's the cause of those problems? Again, there was no documentation to support those things. So once they reach into that area, I think that doctor's credibility got severely damaged for that case, and maybe for other cases in the future as well. See how that plays out. The other situation is when you have the doctor seeing them too late in the Pasek versus UVM Medical Center case from 1520 from September of last year. Here, Dr. Hike saw a claimant and rendered some opinions as to her condition, but the formal hearing doesn't take place until 3 years later. Therefore, the department found that there was no convincing evidence that claimant suffered from any ongoing neck, shoulder, or trapezius issues that interfered with the functionality or activities of daily living after Dr. Hike saw her. So the department concluded, because they do not find that Dr. Hike's testimony is capable of satisfying claimant's burden of proof with respect to her claim for any permanent partial disability benefits attributed to her cervical spine, is not necessary to compare her analysis with Dr. Fincher's under the Geiger standards. So here, again, a 3-year delay between the time the doctor last saw them and the testimony. Usually, again, this is more frequently becomes a problem on the defense side. You have an IME and because you think you're going to trial, or you get a Form 27, and then it just takes a long time before you get to oral hearing. If you're not going to see them again, you got to make sure that that doctor's got all the updated medical records and aware of them, and they incorporate those into their opinions. Because if they're not up to date, if they're 3 years later, there's always a preference to getting the treating physician's opinions to begin with, and then if you're basing your dependence IME's opinions based upon some really old records, their decisions are probably not going to be found to have a whole lot of weight. Somewhat similar to that is the Gregor versus Dynapower case from January of this year, 3-21. This is a hearing loss case. It's interesting the fact that both sides agreed the hearing loss was work-related, but they disputed the impairment rating. So there was an impairment rating based upon a 2018 hearing test. So this is like almost 3 years later. They're basing the impairment rating upon a test that took place 3 years earlier. So in that case, again, there wasn't a whole lot of other opinions out there as to what the impairment rating should be. But this was mostly a dispute about causation, and there was some speculation from non-occupational gun use and the normal aging process. It didn't go beyond mere realm of speculation. There was no specific event or extent that they could conclude. Therefore, they said, quote, there is no basis to conclude that any cause other than claimant's work resulted in his clinically documented hearing loss. So this is a situation, Dynapower, they had done hearing tests for a while. They kind of got not as active in their hearing protection testing mechanisms over the years. And so the last test that they actually measured anything was 2018 for 4%. You would think that, 3 years later, hearing loss doesn't get better. Your back pain may get better. Hearing loss does not get better. It's possible there may have been more. At that point, maybe there would be more argument that, the loss is due to the aging process as opposed to a work-related event, depending upon the exposure and whatnot. But, you would think that 3 years later on, it would be more than 4%, but we didn't have any evidence to base that upon. So they go back to that 3-year-old evidence. So again, SAG, 3 years is too long. Gregor, 3 years is okay, but, not perfect. And finally, I know you all love attorneys anyway, love the attorney's fee cases. Fairbanks versus Town of Bristol, 9 from March 25, 2021. Opinion number 9 in 2020, they found that the claimant had some motions for PTSD at the informal level, made an interim order. Defendant, paid $14,000 in attorney's fees for the workup of the case up until that structure of time. Defendant appealed it, but then withdraw the appeal, and claimant made a new claim for additional attorney's fees and costs. What was interesting about this attorney fee award dispute is that they asked for more money after $14,000, which was a lot to pay in attorney's fees already, for a substantially smaller amount subsequent to that. However, the department specifically found that the claimant did substantially prevail on the basis of the acceptance of the claim and increase in TTD benefits. Other factors favored rejection of request for attorney fees costs, however. No carrier misconduct, no excessive attorney involvement, and encouraging parties to use the informal dispute resolution. Thus, the second claim for attorney's fees costs was denied. So again, we get attorney's fees both at the formal hearing process and at the informal level. The formal hearing is pretty much automatic. Informal is a little more, it's asked for as frequently and it's not granted as frequently. But here, the department is also, signaling that even though you may meet this, the standard for that attorney involvement, resulted in benefit, and clearly in this case it was, they're also looking at the other side of the equation. The carrier had, fully cooperated after the initial interim order about resolving the TTD issue. They voluntarily withdrew that appeal. There wasn't an excessive amount of time involved, and they were trying to encourage the parties to resolve those disputes outside the formal hearing process or outside of the informal process. That they want people to work it out on their own. So here's something out there that suggests that even though you may meet the standard for an award of attorney's fees, if the carrier is acting forthrightly and appropriately, they're not going to award. They may not award attorney's fees. It looks at how much time is involved, and also again the idea is get the parties to work together. Don't come to the department with every little dispute. So compare that to the Loeffler case. Here, they allowed the attorney's fees order, even though the request was 2 days late in the filing. Defendant had suggested that the credibility issues required, going through the process. However, the department concluded claimants' alleged credibility issues did not form a sound basis for the denial of her claim. Moreover, even after claimant's December 2019 x-rays documented a new ankle fracture, defendant did not reconsider its denial, but rather issued another denial in January 2020. So here, they again ordered, this is only one attempt at attorney's fees. The defendant had objected, saying, we voluntarily accepted it and we needed to work out the credibility issues. The department in this case is saying, it wasn't, credibility itself wasn't enough to deny it. And on top of that, you had some actual physical evidence of an ankle fracture, and you still denied it as opposed to reconsidering it. So that's all I've got for today. Thank you all for coming, and we'll hopefully see everybody in person in October, and when we start doing things in real human beings. Thank you very much.